Hello, good afternoon. I hope you can hear me. If you can hear me, can you click the raise hand button just to be sure that we're all here together? Awesome, perfect. Thank you so much for making it to be here. I really appreciate everyone who has made it to be here, and I hope we're going to learn a lot of things from this session. And so today we're going to be having an interesting session with someone I can consider a friend. She has been a very good supporter from the beginning since I got to meet her. A very remarkable person, and that's Odun. Oh, our camera is on. Nice. Hi, Odun. Yeah, good to have you. Thank you so much. I'm going to let us know very soon about who Odun is. She's doing an amazing job in the startup space, apart from her core background as a legal practitioner. And for those of us who have been following us right here at the Edustart Learn platform, we've been having like series of sessions prior to now. We've had sessions with Israel Overe, we've had with Yomi Adedeji of Softcom, we've had with Odun Eweni of Piggyvest, we've also had with Shi Abolaji of the Wilson Lemonade, and quite a number of persons that we're still going to have in line with that. So I've been having conversations with a couple of entrepreneurs who have been having issues with the legal aspects. And Odun being a friend who is also a board member of the Edustart Global Foundation, she has been of remarkable value to us as an organization. And being an expert in that area, I just thought it to be great for her to share from her wealth of experience and also help a number of startups who will be joining us today, for those of you who are here and those who are yet join, and those who also see the recorded version and also learn a couple of things from there. So as we can see on the screen, we'll be looking at startups and legal matters, and Odun will be helping us on that. So just a few things just to help out here. So Odun has founded actually two companies. That's the DIY Law and also the Longe practice. Both of them actually help startups. I hope for those of us who are here, you find there's something remarkable to learn from there. And I would like us to take note of the social media handles on screen. You can follow Odun on LinkedIn, on Twitter as well. Her Twitter handle is Odunoluwa L. I think, am I correct? Odunoluwa L. That's not on screen. So please follow Odun on Twitter, Odunoluwa L, and use the hashtag, as you can see on the screen, that's Startup Legal Matters, and as well as hashtag Edustart Learn. There you can also follow me on Twitter and on Instagram as well. You can follow our organizations as well on Twitter and on Instagram. And I hope that we can learn a lot more. But more importantly, we want the conversations to be ongoing. That's why we are making available the hashtag, as you can see on the screen. Odun can see a couple of things that will be worthwhile sharing. Please feel free, grab your device, go to Twitter, send that tweet, tag her on it, use the hashtag, as you can see on the screen, and let's keep the conversation going. And the whole idea is to see how we can help a lot of startups. As many of you will know who have been following us prior to now, Edustart's mission is to cultivate high-growth entrepreneurs through the existing platform that we have. I want to revolutionize education at the same time. And the whole essence of this is to see how we can fill the gaps around the lack of opportunities. We believe that opportunities are made by people, and the more we can create the platform to help people create opportunities, and in this case, entrepreneurs, the more we can reduce the extent of crime, extent of corruption, and also increase wealth and prosperity at a larger scale. And that's why we do sessions like this, so that we can equip people with the necessary insight to accomplish that. So let me just share a brief on who Odun is. I'll just read this. I'm sure she might be wondering, where did I find this from? Well, I just picked it from somewhere interested. So Odunoluwa is the co-founder, director of DIY, Nigeria's foremost legal technology company that empowers entrepreneurs by providing access to simplified and qualified legal services and information at affordable prices using technology. In addition to DIY Law, Longe also runs the Longe practice, which I mentioned earlier on, a full-fledged law firm providing legal advisory services to businesses and startups. She's dedicated to building and nurturing African entrepreneurs and creating access to legal services, having worked for years as in-house counsel in the investment banking sector, providing dedicated legal advice to private equity, structured products, derivatives, and asset management. Odunoluwa also supports entrepreneurs through the Hague Institute for the Innovation of Law. Odun has made it her life's work to help small businesses through the rigors of doing business in a difficult terrain like Nigeria, even as she navigates the same as the founder of two tasking businesses. She's an alumnus of Lagos State University, as well as the Northwestern University Pritzker School of Law in the USA. Ladies and gentlemen, those of us on board, can you click the raise hand button as you help me acknowledge the presence of a sister, a friend, that's Odunoluwa Longe, as she takes her session right here.
Wow. Thank you very, very much. In fact, this was like reading, this bio looks nicer than the one I have for myself. I don't know where this came from, but I feel to be adopting it. Thank you very much for the introduction. Thank you for having me.
Thank you so much.
It's really a privilege to be here. This is something I enjoy doing. I like speaking with entrepreneurs. I like supporting entrepreneurs. So anytime I have a chance to participate in things like this, I consider it a privilege. So thank you for having me. Thank you to everyone.
Thanks.
Who has come here to listen, and thank you for joining on time as well. I hope that this session proves valuable. And I'm going to share my screen soon, and I'm going to start talking. Or what I want to encourage us to do is, this is a conversation. I know it's supposed to be the way we're structured. I'm supposed to talk, and then there will be Q&A. But please feel free to drop something in the Q&A anytime you have a question. I'm not sure whether if I share my screen, I'll be able to see it. But I have a colleague online as well, Anne, and she will let me know if there's a question in case I don't see it. But I'm happy to stop at any point in time to address your questions. It's going to be less presentation from me, but I want to actually help you in your businesses. So if you have any real cases you want me to apply what I'm talking about to, please feel free to let me know and put it in the Q&A, and my colleague will let me know and will let me know. All right, I'm going to share my screen in a second so that we can start. Okay. Yeah. So I'm guessing you can all see my screen now, right? And we're going to be talking about, okay, awesome, startups and legal matters, as he said. And one of the things that I've realized over time is when many people start businesses, especially in this part of the world, we tend to just start, you know, we don't put the right things in place, we take legal for granted, and more often than not, later on, it comes to bite you. And usually it's at the point where you want to make other people part of your business, when you want to fundraise, when you want to maybe go into a very huge partnership, and they're like, oh, let's conduct a due diligence on you. Let's see whether you're properly structured. That's usually when entrepreneurs start running around. From experience, based on what I've seen, like most times, that's when clients then come and meet us, and we're having to put things in place and make sure things are done properly. There are few people that don't do that, and that's really commendable. For being here today, I want to believe that, the fact that you have taken time to join this webinar, that means you want to do your business correctly, or you're running your business correctly. I don't know how many people have a business or just starting or plan to start. It's information I wish I had, but we'll be talking about everything. So my presentation is not a lot of writing. It's just the talking points I have, because it's mostly going to be a conversation, as I said. So if you have a question as I'm talking, please just send it in the Q&A, and Anne will get it across to me. So there are three things we're going to be talking about, three talking points: starting your business, then running your business, and then scaling your business. Those are like the three aspects of your business anyway. So we're going to be talking about your legal needs at each point in time. So we'll start with starting your business. Under starting your business, I'm going to be talking about the founder's relationship, the legal entities that are available to you, the things the information you usually have to prepare when you're setting up your legal entity, and then I will just talk briefly on licenses. Now, the reason why I raised this is because over time, from our clients, we've seen that people have these questions, especially where we talk about where I have the object shareholders. Most people don't know the difference between a shareholder and a director and all of that. So we will talk about that as well, or even what a share is, but we will speak about that. So let me start with founders' relationship. When you're starting a business, more often than not, you're going to start with somebody else. You really, it's quite common that you will have a co-founder. If you're going on your own, that's awesome. But the minute that you have a co-founder, even if your co-founder is a family member, whether it's your sibling, whether it's your wife, your spouse, or anything, it is advisable that you put some documentation in place. We've done, so usually the documentation is called a founders agreement, and I'll tell you more about what a founders agreement involves and entails. But to give you context, we have drafted founders agreements for spouses before, so it is advisable that you get it done. In fact, by the time an investor is coming into your business, if you're married, it gives them more comfort if there's paperwork that, okay, yes, they are married, but they are also approaching this as a business. So what's a founders agreement? It's basically that document that tells the duties, the obligations of those involved in setting up the business. Sometimes when you don't put things, most times when you don't put things in black and white, it will lead to ambiguity. Some people think that when you document things, that if you put agreements, that means we don't trust each other. That means we are that we're envisaging that we will fight. Contrary to that, agreements actually clarify things, because when you then start the business, there's no assumption that, I thought you were in charge of marketing. No, I thought you were in charge of developing the pipeline, or you were in charge of overseeing the programmers or outsourcing, everybody knows the role they're supposed to play in the everybody knows the role they're supposed to play in the business. So I do advise that you have a founders agreement. A founders agreement will talk about your roles. It will talk about the ownership percentage for each person. You know, do I own 50% of the business? Do I own 20%? Do I own 30%? It talks about how do we make decisions when we set up a company. How are we going to appoint board directors? How are we going to admit investors? How are we going to fundraise? So it talks about the decision-making process as well. And one very important thing that it talks about, which typically if this was a physical session, I will explain using a board. But I'll try to use words to explain it as much as possible, is vesting. Vesting actually means, the meaning of vesting is earning your shares, coming into ownership of your shares. So to provide context, when you start a company, let's say you start and there are two shareholders, each one, for simplicity, will make it 50-50. What vesting does is, even though we're starting the company with 50% ownership each in the company, we're going to put in a mechanism, an arrangement that makes it possible for us to collect the shares back if anybody leaves. And why people put in vesting, why you put vesting in place is, now, both of us, let's take, for example, if both founders are students, you start business as a student, and both of you are like, oh, we're very passionate about this, we want to go ahead with this. But along the line, one person probably maybe gets an exciting job offer and decides maybe they don't want to go on with the business. It is unfair that they would leave running the business and then still have 50% of the company. So what vesting does is, in case this person 2 years down the line decides that they want to do something else, you give up your shares. It builds a mechanism for you to return your shares, so that the shares that you return, you will earn shares for the period that you have worked. But for the period that you haven't worked, you return your shares, so that if someone else is coming into the company, they get those shares, or the person that continues to run the company holds on to that shares. I hope that's clear. Usually I would draw how the vesting works, what year 1, year 2, year 3, year 4 does, but now I have to just use my words. But it is a very, very important concept. In fact, we will talk about this again when we come to fundraising, because apart from putting in it in when you do your when you have your founders relationship, when investors come into your business, especially when they're investors that are going to own shares in your company, which we typically call equity investors, they will ask the founders to put investing in place, because they want to be sure that they are putting in their money. They want to be sure that the people that they're investing in are committed to the business. So they will say, if you decide to leave this company before 5 years or before 4 years, then you give up your shares. Even though you started it, you give up your shares, because we are putting in our money and we are betting on you running this company on the long term. So basically that's what vesting is, and we'll talk about it again when we come to fundraising. So for your founders relationship, you need to just put all that in place and make sure that you have a founders agreement. And once you have all this in place, it mitigates the occurrence of someone abandoning your company halfway. We've seen founder conflicts happen before, and one person's like, I'm not doing this again. But the founders agreement has already said, okay, what happens when someone is leaving? So it really helps. And I advise that when you start a business, you have that in place. Legal entities, I'm not going to spend too much time on talking about legal entities, but there are I'll say there are 3 entities you can use to start a business in Nigeria. 2 are profit making, 3 or 4. So if it's profit making, you can either use your business name or the company limited by shares. Business name means you're a sole proprietor. It is not technically an entity. It is literally what it means, business name. When you register a business name, you are the one in your personal capacity that is doing your business. It's only that you can now trade as a name. So you could be Odunoluwa Longe trading as the Longe practice. It doesn't mean that Odunoluwa Longe is separate from the Longe practice. They are the same when it's a business name. However, when you do a company limited by liability, which is also for profit-making business, in that case, that means Odunoluwa Longe is different from DIY law. There are two different places, using DIY law as an example. And the reason why I use these two entities is because they are literally that. DIY law is a limited by a liability, while the Longe practice is a business name. And the reason why the Longe practice is a business name, because it's a requirement of some professions. Like if you're a lawyer, if you're giving legal advice, to some extent, you are making yourself personally responsible for the legal advice you're giving. So it's compulsory that all law firms in Nigeria are registered as business names and not limited liability companies. So that's why Longe practice is a business name. But when it's not compulsory, I would always advise that you do a limited liability company like we have with DIY law. If there are any potential, risk and everything, the risk attached to just the company and not to you in your personal capacity. Nobody is going to come after your private assets. Now, if you're running a social enterprise, you can run it. We don't have any entity dedicated to social enterprise in Nigeria, but you can run your social enterprise either as a profit-making social enterprise or a non-profit-making social enterprise. For profit-making, it will be the one I have described. But if it is non-profit, you would use either the incorporated trustees or the company limited by guarantee. Those are the two types of entity you can register as a non-profit. And what it means, it doesn't mean that you can't do business with them or you can't earn revenue. You can earn revenue, but everything that you earn goes back into promoting the costs. You can't distribute profits. In a limited by liability, you can distribute dividends, you can distribute profits, in addition to salaries and all of that. But when it comes to a non-profit entity, which we typically call NGOs in Nigeria, if you come to an NGO, you cannot distribute dividends, you cannot distribute profits. Whatever money that is made, whether by donation or by rendering a service, goes back to furthering the costs of that NGO. So those are the things you can use as a social enterprise. If you decide to use a profit-making entity as a social enterprise, it always helps then have like a charter as well that describe your social focus in addition to, because that won't be inside the document you use to set up your company. So it's good to just have like a charter that says, okay, this is why we're a social enterprise and this is what we do to promote social good and to be impact making. Then the next thing I'll talk about is some of the things you come across when you're setting up a limited liability company. And the reason why I focus on that is because that's the most popular entity for when you're setting up a business. You need to have an object clause. An object clause basically states the purpose of your business. Are you setting up a business for advertising? Are you setting up a business that provides software development? Is it to sell clothes? Those are the things you put in your object clause. And I've seen this come to bite people. We had a client once that it was at the point of investing when the investor was doing due diligence. That was when they hired us. And that's when we realized that when they incorporated the company, they didn't put, the company was an advertising company. That is all they do. It was and that is why the investor was investing, but there was no advertising in their object clause. We then had to start rushing. Apparently at the time when they were registering, they said the lawyer who registered for them and advised them to remove advertising because, for you to incorporate an advertising company in Nigeria, you have to have a 5 million share capital and you have to have one of your directors must be APCON certified. At that time, they couldn't get this thing, so they decided to just register. So it was at the point of due diligence, we had to quickly do this, or else the investor would not have parted with the money. So it's important that you reflect the business you're setting up in your object clause. Shares are units of ownership in a company. So at every point in time, we know that a whole thing is 100%. So at every point in time, a company's shares are 100%, no matter how many shares. Sometimes you have a company that has 1 million shares. Some will have 100,000 shares. It can be any number, but at every point in time, they're 100%. Now, what shares does is exactly as the word denotes, it's a share of a company. It's the proportion of a company. So each person will have, 20% of the shares, 30% of the shares, or, sometimes it's 99% of the shares, depending on what the total is, then you now have units making up that percentage. It's just, it's an evidence of ownership. So the number of shares you have is the extent of your ownership in that company, and also the extent of your liability and exposure to that company. As I said, it's separate from who you are personally. So you only exposed to the proportion of your ownership in the company. Shareholders, as the name implies, are the owners of the company, those who own shares in the company. So if it's just usually at the beginning, it's just the founders that are the shareholders of the company. Now, the shareholders, what's in the good thing about a company is it separates ownership from control. Control is done by directors. Ownership is done by shareholders. To give you an idea, I will give you an example of a public company, First Bank. First Bank has only God knows how many owners. Almost everybody says they have shares in First Bank. As long as you, even if it's one share you hold in First Bank, then you're an owner. Then you are an owner of First Bank. But the control, you are not in control of First Bank. The control is done by the directors of First Bank. So it's the same thing when it comes to a small business. Most times for a small business, of course, the shareholders are the directors, but they can be different. You might be a shareholder and not be a director. You might be a director and not be a shareholder. It doesn't have to be the same set of people, but when you're starting a company, it's typically the same set of people. You are both the owners and the directors, but you act in different capacity. What is expected of you as an owner is different from what is expected of you as a director. As a director, you have responsibilities to your company. We call them fiduciary responsibilities, meaning fiduciary is like trust-based. So as a director, you're responsible that the company is run properly. You're responsible for the company to be governed properly and to be, that there's no fraud. You're the one that makes sure that you enter into correct deals, you enter into the right deals and you're not careless or negligent in the way you do business. And then in Nigeria, it's also compulsory as of today to have a company secretary. When you're starting a company, the company secretary could be one of the shareholders or directors as well. You don't need to spend on this, but as you begin to get active, it is better to appoint either a lawyer or an accountant as your company secretary. A company secretary, the role of a company secretary is to ensure corporate governance, to ensure that meetings are recorded, to ensure that the directors are doing the right thing, resolution, general corporate governance. And the regulatory licenses, when you start your business, you also want to be sure that you have the right regulatory license when you start. And this differs from business to business. So if you're into the food, cosmetics, drug, it goes without saying, you need to get your NAFDAC license. If you're running a logistics company, you're actually regulated by NIPOS. I know that a lot of people do logistics now, and they just think, most people assume that you can just go in to that business is actually regulated. There's been a law for a long time that says that you must register with NIPOS. And I know that in recent times, NIPOS has decided that they want to start enforcing it, but I think they're looking into having an SME profession. So if you're going into the logistic business, you need that. If you're not going into the logistic business, say you're just a business that has a bike, then you don't need a license from NIPOS. But there are other things you need. If you have a bike that delivers, maybe you have a food business and you have a bike that delivers the food, you need to make sure that the bike has the necessary licenses to be on the road. And if you are branding it, you need to also make sure that you have the branding licenses. In Lagos, it's called LASA, the Lagos State Advertising Agency. So before you can brand the car, before you can brand the bike, you have to have your LASA, or else it will be confiscated once it starts delivering. And then there are different permits and riders permits and all of that you need to have. So basically, depending on your sector, you need to make sure that you fulfill whatever regulatory license. It goes without saying that if you're doing anything financial, you're looking at either the CBN, for the fintechs, you're looking at CBN, you're looking at the SEC or any of those regulatory agencies to get your license. As a stopgap, I know that people sometimes go into agreements with people who have the license for you to first test your product, and that is also sufficient as at the time you are starting. Any questions so far? It looks like we're doing good so far. I don't have a question yet for me. Okay, so next I'm going to now start talking about running your business. These are the things you then begin to encounter when you're actually running your business. You've taken care of all the right things when you started off on the good news. Once you start running your company, at some point you begin to have employees or consultants. I'm using consultants as a generic term to define everyone that is even outsourced services. When you start, you might outsource your accounting and your bookkeeping and all of that. If so all those fall under consultants. And when you're starting employee and consultant, you want to make sure that you have all your documentation intact. From employees, it's an employment agreement. It's very common to just see people give an offer letter that just says you start so date and your salary is this and nothing more. It is when the engagements then start, like, okay, do I have leave days or not? Do I have a break time or not? Okay, I've worked on this. Is it for me or the company? Those things start to come up. That's why you need an employment agreement. The same with the consultants. Okay, I'm paying you for work. I'm paying you to do some things, but the information you have about my company, is it yours or is it mine? Those are the things you put in, you deal with under your employment agreement or your consultant engagement letter. So the important things you want to be sure that are covered in this documents for your employee agreement and all. When are they starting? Oh, sorry, I just saw one question. And let me address that because it was on shares. Is there a limit to the question? Is from Emeka Iwela. Thank you. He says, is there a limit to the number of shares a company can have? And how do you determine the worth of each unit of share? Now, there's no limit to the number of shares you can have. Our laws in Nigeria are old. So for now, I think the minimum, if I'm correct, is 10,000 shares. But usually for small businesses, a 10,000 naira share capital. For small businesses, we recommend a 1 million naira share capital. That you start with a 1 million naira share capital does not mean that you must have 1 million naira. At the end of the day, I think the total cost for getting that running is about 40 or 60,000 naira. But usually you will have 1 million share capital divided by 1 million shares of 1 naira each. So that means that each share is worth 1 naira each as at the beginning. Now, as you begin to start business, as you start your business, you begin to acquire assets, you begin to have your accounting books, it changes. Now, there's something we call a nominal value of a share. That's usually what you would have in the Corporate Affairs Commission record, which is most times maybe 1 naira. But your accounting value is different. It's at the end of the year. By the time the accountants do your books, do you have, does the company have a house? Does the company have machinery? All this begin to affect the, your assets and liabilities begin to impact the value of your shares. And that's why you will find that, companies on the stock exchange, listed companies on the stock exchange, their share value goes up and down depending on what happens. For smaller companies, you probably will wait till the end of the year during your accounting year to determine, okay, what is the new value of our shares? But for the bigger you can just see how the shares move, the value of the shares move up and down for the public companies. And another time when you talk about the value, how you determine the worth of each share is at the point of investment. If it's an equity investment, your investors are going to want to determine how much is this, when you talk about valuation, but I don't want to go into that now. I'll go into that when we get to fundraising. It's also that is also part of the value of your shares when you start talking about valuation, and I will go more into that. I hope I have addressed your question. There's another question from Akintunde Joshua. He says, please, can you explain the difference between directors and shareholders? How are the directors selected? Okay, sure. Okay, I'll go over that again. Your directors are the ones in control of the activities of the company, while your shareholders are the owners of the company. The way the legal entity has been structured, the way a company is structured, is that it has separated those who own the company from those who control the company. Those who own the company are the ones who own shares, and all they do is all they have is ownership. But those who are directors are responsible for the strategy of the company. Now, most times with small companies and small businesses, the shareholders are also the directors. But as you grow bigger, this changes. And I'll use the example I used earlier, which is like First Bank. Anybody can buy First Bank shares on the stock exchange. And once you buy shares, you're an owner of First Bank. You automatically become an owner of any listed company by you buy the shares. But that doesn't mean that you can determine what happens in the company. You're just a shareholder. Those who can determine and who should determine what happens in the company are the directors. They are the ones in control. So when you have a board of directors, these are the people that determine the strategy. They are responsible for the decisions, Who does the company enter into partnership with? Where does the company raise money from? What is the business direction of the company? And just to provide more context, there are two broad groups of directors. The ones you call executive directors and the ones you call non-executive directors. The executive directors are the ones that are paid. Once you see executive in front, that means they're paid a salary, like the chief executive officer, or you see an executive in front of them. They are paid a salary by the organization. And that means they are responsible for the day-to-day, everyday going-ons of that company. However, the non-executive directors are the ones that maybe you appoint because of their profile, because of what they can do for your company. Whilst they are also still responsible for the company, they are not in charge of your day-to-day, and they don't earn a salary from the organization. The minute you start paying someone a salary, then they're an executive director. But when you don't pay them a salary, they're non-executive director. Of course, you can give them allowance, you can give them gifts. It's not uncommon to have like sitting allowances for meetings, but that is for big companies. As a startup, you shouldn't be giving anybody sitting allowance because you barely earned enough money yourself. I hope that addresses your question as well. And then I will continue to discussing running a business. Please keep the questions coming if you have any additional questions. Okay, so back to, sorry, that's running your business. Now, running your business, I was talking about employees and consultants. It's important that you document your relationship with your employees and consultants for a number of reasons. Now, you want to talk about for an employee, you're going to put the resumption dates when they started working. You're going to talk about things like leave days. When do you go on leave? But I think most important to me is you also want to talk about things like your intellectual property. Who owns the IP? Now, generally world over, the creator of any work is the owner. So if I take a picture, if anybody takes a picture of me right now, that I am in that picture does not mean that it is my own. It is the person who took the picture that actually owns the picture. There have been incidences, I think this was in the US, that a magazine sued the person that was inside the picture because the person used the picture without the magazine's consent. So even though it was a picture, TMZ still sued her because she used it without their consent. They own the IP. So the creator of a work is the owner. The same way, if I code, if I do some development if I do some programming in your products, whether I am an employee or not, except it is stated in my employment agreement, the employee is the owner. So this is where an employment agreement becomes very important. In the employment agreement, you're going to discuss in IP ownership. Now, whatever work that is created by that employee in the course of their employment for the business belongs to the company. It is assigned automatically to the company so that there's no controversy in the future that I'm the one that did this part. I coded this part so I can use it for my own stuff when I leave, when I stop working with you. And then they go and do exactly what they built for you. So you can own so it's important that you document that in your employment agreement. The same with the consultants. Many of us sometimes outsource software development when we start. If you don't have an IP assignment clause in that letter, in that engagement letter, that you paid them money has not conveyed ownership of what they built, of the websites they built into you, or the app they built, that you paid them money is not enough to convey ownership in you. You have to put it in the engagement letter that the software, the code, the source codes, and all of that belong to you. So these are things that are very, very important to include. It's also very important to include confidentiality information so that they don't go and tell your trade secrets and business secrets to other people. Depending on what it is, you also want to restrict them from getting your customer. So if an employee leaves, they should not go and start their own business and then take all your customers. So you just want to make clear that you cannot take my customer. It's okay for you to go and do, if you're not stopping them from competing, which is fair enough. I don't think There's something called a non-competition clause, but for personal reasons, I'm not a fan of it. A non-competition clause says that if someone works with you, they can't compete with you in the future. But, I think competition is good for business, but that's a personal take. But there is a legal concept called non-competition. But what non-competition is different from the non-solicitation that I'm talking about. Non-solicitation is they should not take your customer. Even if they were the ones that brought the customer in, they are the customer of that company. So you will restrict them from working with any customer of your business for say 2 years and all of that. So those are the things you want to make sure are covered by your employer and consultant agreement. You also want to make sure if it's a consultant that they cannot steal your employee. So that you worked with somebody does not mean you steal. We're currently involved in a situation where the business that we represent, the second people to other companies is part of their business. Our client seconds people to other companies. So they seconded one of their staff to the company. And now they're in that bit of, no, you can't hire. They want to hire that person directly. Those are the things you want to restrict against. And unfortunately, they didn't put in the employment letter when we were not working with them when they put us in the employment letter that you cannot work with a client or customer of the business. So those are the things you want to make sure you always document. Intellectual property. I mentioned IP right now as I was talking about, I mentioned protecting your IP. And I was talking about employees and consultants. Now, there are different types of intellectual property. There's something called copyright, there's something called trademark, there's something called, and these are the registrable ones. So there's copyright, there's trademark, there's patents, and I'll explain what each one means. Copyright is for creative works, it's for creativity. So things that are written, things that are documented, things that are drawn. It means that if you protect it for a certain number of years where the protection is valid, no one else can use that material. In Nigeria, people have been known to protect their source codes using copyright because we do not have patents for software in Nigeria. So sometimes when people want to protect certain processes, they document it, they put it in writing, they put the source code in writing or in a CD and then apply for copyright protection so that nobody uses that same type. And trademark, which is quite common and it's very important as you grow your business, is protecting the name in which you do business. So for instance, DIY law. DIY law is a registered trademark with a trademark registry. So if anybody starts business in Nigeria now and tries to use DIY law, we will come after them. They can't use it. We'll write a cease and desist letter. So that's what your trademark does, because so that people cannot they don't take advantage of the brand you've built. It protects your name and it protects names that are close to your name. So if someone comes now and tries to change it slightly and says maybe DIY law N, even though it's not DIY law, we can actually say this is close and the person is doing the same business that we're doing. So this is close and it will confuse people. And we can, because we've protected DIY law, we can do that. The way trademarks works, the protection is for the type of business that you do. There's something called classes in trademark. There's certain classes and protection is based on the class that you are. The bigger companies, the Coca-Colas, the Apples, there are even some businesses that are not in Nigeria, they are registered, their trademark is registered. They register in all classes, there are about 40 something classes, but that's expensive for a small business. It's not even realistic. So what you want to do is identify where you're doing business and protect your trademark in that class. So that nobody doing a similar business can use the same name. As you grow bigger, you then can begin to even protect yourself in classes where you do not do business. Patent is for inventions or an improvement of an invention. So if you've created something that has never been created before, or you've taken something that has been created before, and you are then now, you've improved on it considerably and can show that you've improved from it, you can apply for patent protection. Now, the thing with all these protections that you apply for is the minute you apply for any protection, it becomes public knowledge, but nobody can use it. But when you don't protect it, if you are so big on secrecy and you don't want anybody to know, then you probably don't want to apply, because the minute you apply, anybody can go and do a search and find it and becomes public property. But then they can't use it. They just see how you're doing things, but they can't use it for a certain number of period. Also note that these protections are they're jurisdictional. They protect you in a country. You cannot say that because you have patented something in Nigeria, then you can go to America, or because you have a trademark in Nigeria, that then nobody can use that brand name in Ghana. Someone else, there can be a DIY law Ghana if you've not registered if we've not registered DIY law, if you've not protected DIY law in Ghana. So that if once you start expanding to other markets, then you want to also begin to trademark your brand name or protect your patent or whatever, your intellectual property in those markets. Or if you already know that there are potential markets you're going to enter into, you also want to do that ahead of time. And of course, there's also making sure that you enter into agreements. Another way of protecting your intellectual property is entering into the right agreements with everybody that deals in your intellectual property in whatever way, whether they are part of creating that intellectual property, in which case they have to assign it to the company, or whether they have access to it, and then you have to make sure that they are bound to confidentiality. Then we move to basic agreements that you would come across as you run your business. One is the NDA, that's the non-disclosure agreement. It's sometimes called the confidentiality agreement. It's basically saying that any information that you get to know in the course of our dealing together as a business, you cannot reveal it and you cannot expose it to others. And when you're entering into things with anybody, it's important you have an NDA protection. I will just raise a flag now and say that most times when it comes to equity investments, investors will not sign an NDA with you. And that is not unusual because investors get to see so many ideas. They get to, many people come to pitch to them and say that, oh, do this for our, will you invest in our business? Some of them being the same thing. So if they signed an NDA with everyone, you might think that because they didn't invest in you and invested in someone else, they then went to reveal your business secret. So it is unusual for investors to sign an NDA. Of course, when they start talking actively to you after the pitching stage, by the time you're exchanging term sheets, they are the ones that would even put a confidentiality clause in it. At that point in time, an NDA kicks in. But at the point where you're pitching and sending your pitch, it's not likely that an investor will sign an NDA. But people, the business partners and all, you want to make sure they sign an NDA, your employees and your consultants as well. There's another question here on IP. It says, can intellectual property be co-owned? Oh, sorry, I wasn't charging my computer. I'm doing that now. Just 1 minute. Okay. Yes. Can intellectual property be co-owned by employer and employee? If yes, what happens when the employee exits the company? If it belongs to the company, an employee should not own ordinarily, the employee should not own the intellectual property. Even though they were part of creating that intellectual property, by reason of their employment, you would have put it in their employment letter that they would assign everything they do in the course of the business and for the company to the company. So you don't want to put yourself in a situation where it belongs to an employee. If for any reason whatsoever, which usually happens when it comes to maybe patent application, because when you apply for a patent, they will ask you for the creator, the maker of the patent is different from the owner. When it comes to that, yes, you can put their name as the creator or the person who worked on it, but the owner should always be the company. And if you intend to, maybe it's something so great and you feel that the employee should be compensated, you make sure that everything is assigned to the company. Then you can enter into a royalty situation where, okay, we will pay you royalty just because of this, but not because they own it. They shouldn't own it, but because you're just compensating them for it. You look at all the big tech companies, they have a lot of brilliant software developers and a lot of brilliant minds. You look at the Googles, the Facebooks, and all of that. They have all these brilliant minds working with them. They don't own the intellectual property. They've come up with things. You will see someone that said that I was the one that created YouTube, or I was the one that worked on Google Maps. It's for Google. It does not belong to the employee. So you really do not need to have an employee be an owner. Yes, they can get the accolades and the recognition that comes with them being the one that was part of the team that created it or the person that created it, but they shouldn't be an owner. So that way, when the employee leaves, it continues to belong to the company. what happens when a party this is another question. What happens when a party contravenes the NDA? Now, most NDAs will always have a clause that says that if it has like a dispute resolution or clause. When a party contravenes an NDA, there are different ways you can do it. Usually it is resource to court, which is like really long story, but you can also write a cease and desist letter. Now, because the court processes can be long and all of that, you might say, okay, you want to write to the party first. If it's something that is continuous, the party is still doing it. Or maybe they reveal it to someone that has made money from it. You can decide to write letters to the people they've released it to, that this person breached this trust and we're going to be taking legal action. You can do all of that first, but usually the resort is to, if say they use they use your information to make money, you can go to court and claim that as a result of the information they were not supposed to share, they used it for this economic activity, and that economic activity, the benefits of that economic activity, that commercial activity should be rightfully yours, and that you're claiming all the money that they've made from that. So there are different consequences, but the easiest starts with at least writing a letter if it's a continuous case. So the next, so that's with the NDA. Now talking about MOUs. Now what we find is, before you find a lot of people say, I want an MOU of this. Before they say, I want an MOU, I'm doing this, I want an MOU. The meaning of an MOU is Memorandum of Understanding. And the legal enforceability of that MOU is exactly what it means. It is just an understanding, except if it is expressly written in the MOU that this is binding. Typically, an MOU is not a binding document, meaning that if anything happens, you can't, I don't have to go ahead with it. It is just, okay, we started discussing something. We have an understanding. Let's put paper together. Eventually, we will still sign substantive agreements. We will sign proper agreements that will govern this relationship or that will govern this transaction. So if someone sends you an agreement that is called MOU, if your intention is for it to be binding, please look at it properly and make sure that there is a binding clause in it that says that this MOU shall be binding. But ordinarily, MOUs are not binding. They are a precursor to a proper agreement that is to be signed. But we even big companies and big organizations, we hear them say, oh, let's sign an MOU, let's send you an MOU, and in their mind they are entering into a binding legal agreement, which is actually not the case. It is not a binding legal agreement. Now, if you're entering into a partnership, you're now going into a business that together, you've maybe signed the MOU or you didn't sign an MOU. What you want to enter into is a collaboration agreement. Both of us are going to do this together. We are collaborating to get this result. The collaboration agreement is quite popular among small businesses, because sometimes you work together. Maybe if I do this for you, you will do this for me. If I do your marketing for you, you will do my books for me. Or maybe together we will explore this opportunity. You will take care of the HR part. I will take care of the development. Let's apply for this opportunity together. Let's apply for this agreement. What you can enter into is a collaboration agreement. We're collaborating to do things, and that is binding. A vendor agreement are the things that your vendors sign, or you sign with other people as a vendor. These are basically service providers, someone who's going to supply you with things, or or someone you're going to supply with things. That's where the vendor agreement comes in. Website documents. Almost every business has a website these days. Even if you are doing an offline business, even if you're maybe running a fashion business, you would have somewhere where people will go to look at it, other than Instagram. I know that, yes, many of us do social commerce, social media commerce now. But once you begin to have a website, and you want to have your website documents to govern, and the standard website documents, like the simplest form is, you must have at least a privacy policy, and you must have the terms and conditions. Privacy policy is what it is. You're going to be telling the people that come on your website what you use their information for, how you're using their information. And now with the introduction of the NDPR, which is the Nigerian Data Regulatory Protection Regulation, which was released last year, I think it was last year, it was released by NITDA. There are certain things that must be in every privacy policy. There's certain information you must put in place in terms of it. So once you're running a business, you need to have your privacy policy, and the privacy policy must be in compliance with the NDPR. Terms and conditions are the terms of using your website. Is my website just for information purposes? Can you do business on my website? Can I take your orders through my website? And if you take orders, how do we take our orders? Who do you report to? What is my refund policy? What is my returns policy? Do I not return? Those are the things you should put in your terms and conditions. And many a times, people don't read them. We all accept them, or even when we don't have to accept, most websites will say, by reason of using this website, you do this. But there may come a day when something will come up, which does happen, which we've seen. And then we'll say, oh, that's when you will thank God that I actually had this thing. I protected myself against this thing in my terms and conditions. So that's the importance of the terms and conditions. That's when you realize that, oh, I am not, if you go to our terms and conditions, this is what we say we do in such circumstances, even though people don't read it. And it is why it is very important not to copy and paste. I know that many people also copy and paste privacy policies and terms and conditions. If you copy and paste, you might find that you are not protecting yourself against what you need to protect yourself, or you go and copy and paste from another jurisdiction, and you see that you will realize that those things do not apply in Nigeria because our laws are not as sophisticated as that jurisdiction, and then you might as well have not protected yourself. There are other agreements that you would usually use, but these are the most popular that you would use when you're running your business. Then we have, I'll talk about corporate governance as well. When you start your business, when you start running your business, it's always good to have good corporate governance in place. The law says that shareholders should have meetings at least once a year, which is called your general meeting. And the first one should be held within 18 months of setting up your company. That's your first annual general meeting. They can have more than one, but at least you must have one. Your directors too should meet often, and in those meetings, minutes should be taken. Now, a meeting does not, we could have a meeting this way. A meeting could be just two of you saying, okay, we are approving the account, but it's just good again, all these things start to show their face and start to rear their head at the point where you're expanding and where you're trying to raise funds. Have you documented some decisions? And that's why at meetings you have resolutions as well. We've resolved to do this. Resolutions are basically decisions documented in paper. The decision of the shareholders is to do this. The decision of the directors is to do this. That's what you put in the resolution. So that's part of the corporate governance. Filings. The filings you have to do to different agencies. The simplest of which, if you're not licensed by any regulatory body, is your filings to the Corporate Affairs Commission and your filings to the Federal Inland Revenue Service or the State Inland Revenue Service of your country. Of your state, your state of operation. So you want to make sure that you do these filings regularly. With the CAC, it's annual. With the FIRS as well, it is annual. But with the State Inland Revenue Service, usually it's the payee you're paying, and payee is your personal. Is income tax. I'm sorry, the acronym is not pay as you earn. Yeah, pay as you earn is the meaning of pay, and is deducted from salaries at source. The employer is meant to deduct from all employees and then remit to the State Inland Revenue Service, which in Lagos is LIRS, every month. At the end of the following month. For the Federal Inland Revenue Service, you do company's tax at the end of the year, and you do your VAT filings every month as well. Now, note that I said filings. Filings does not necessarily mean payments. If you do not make a profit, you are not expected to pay you're not expected to pay companies income tax. And now with the new Financial Act, there are even more concessions for small companies. But you still have to file and say that I did not make profits. It is compulsory that you file. There's a penalty for not filing. They don't say you have to pay. So you file zero returns. The same thing with VAT. You're expected to start remitting VAT within 6 months of you starting a business. If you don't sell anything, then there's no VAT to be remitted. VAT is incurred by the customer, the value added tax. So whenever you're issuing invoices, you would add a VAT. It's now 7.5%. It used to be 5%, but was changed to 7.5%. That 7.5% that you add, at the end of every month, you're supposed to take that you're supposed to file that. And if you did not sell anything, if you did not make any income, you don't have to pay anything, but you still have to file the necessary form and submit the necessary form. There are penalties for not filing, so please make sure that you put that in place. Okay, there are a few questions here. One says, this sounds like a lot of documents for a young founder to create. Do you advise young startup founders to create this themselves with a team or pay a company like DIY to create them? What are the advantages and disadvantages of both approaches? Honestly, not because I am a lawyer or because I run a legal services company. I think it's always good to get this from another source. I know that people go to Google. There's a mug that I've been saying I want to get that says your Google search is not equivalent to my law degree. That is so true. You really want to make sure that these are done properly because laws change. I just mentioned the Financial Act that increased VAT from 5% to 7.5%. You might not know it as a business owner. It's important that you focus what you know is what you know and you focus on your business. As a lawyer, I'm not going to assume medical information about myself. So I would say yes, you can go to, a place like DIY Law. DIY Law is not too expensive. So for the simple contracts, I think you can get an ND on DIY Law. You can get a privacy policy on DIY Law, just some basic documents. I think there's an employment contract as well. You just need to answer. And I don't think they're very expensive documents, maybe 3,000, 5,000. You enter it, you answer a few questions, and then you can download it. I would advise you use that option. And then as you grow bigger and have things that are more specific, you might want to get a lawyer. You might want to get someone that can give you something that is customized to your business. There are a lot of people that do small business lawyers or startup lawyers now, and it's okay to speak with every one of them. But I would encourage you strongly. It is a good investment to making sure that you have all your bases covered. That you've covered everything properly. It's good. It's worth the investment on the long run. The disadvantage, since you said advantages and disadvantages of both approaches, of course, if you do it by yourself, it's cheaper, but you expose. So that's the main advantage of doing it by yourself because you can probably find templates on Google, but you risk exposing yourself to liabilities and not taking into consideration recent laws and recent developments that are at play. Next question, there's another question here that says, all those into online marketing business, blogging business, or Forex business, are they exempted from paying tax? Nobody is exempted from paying tax. So tax is based on residency. If you live in Nigeria and you earn revenue from anything, then you should pay your tax. If you're into online marketing and of course, and you get paid for it, which you will, earn revenue, you should pay your tax. So there are two ways. For a business name is different. The way you remit your tax is different. A business name, the only concern you have with the Federal Inland Revenue Service is your value added tax that you impose on the bills you give your customer, on the invoices you give your customer. But in terms of your end of year, because you're a business name, any revenue you make it to yourself. So you don't make a corporate company's income tax filing at the end of the year. What you make is, it's called PITA, the personal income tax. You go to your nearest LIRS office if you're in Lagos, or Ogun State Revenue Service if you're in Ogun, whatever state you find yourself, because you're a resident of that state and you made money from whatever business it is, whether the business is abroad, whether the business is in Mars, the fact that you live, your taxation is based on residency, where you live or where you operate your business, then you have to pay your taxes. Whether it's blogging, whether it's Forex, any gains you make on your Forex business, you should pay taxes on it. Can we get your contact for offline? My contact will be at the end. My last slide is my contact. So yes, I will provide that. Okay, so back to, so we've spoken about filings and why you have to file so that you don't get fined, whether or not whether you're going to pay anything in continuation of that, in addition to that filing. It's important that you do your regular filings. Reporting is similar to filings. Are there any reports you need to make when you start having stakeholders or when you start having investors? Do you do monthly reporting? Do you do quarterly reporting? And at the end of the year, you also have to have like your end of the year financial report. So make sure that you have all that in place as part of good corporate governance. Even if you can't afford to get an auditor, as a small business, you decide not to audit your end of year, make sure you have an annual report. Let's, with your bookkeeping, if you use a bookkeeping software, try to generate the end of the year report and see what your end of year is. But if you can, I will encourage you, if you have an outsourced accountant, they'll give you an annual report. The minute you can afford it, begin to audit, especially if you have fundraising ambitions in the future. For investors want to know that you have that you're diligent when it comes to your financial practices. So that's also good corporate governance. Okay, let me answer the next question. And if you have any more questions on the running your business, let me go back to that slide. If you have any questions, please send them in before we go into scaling of businesses. There's a question here that says, for an SME or startup, after business registration, is it compulsory to register as a limited liability, even if you don't have the resources to do so? You don't have to register as a limited liability. You can start as a business name. You can just, as a sole proprietor. But as you expand and as you enter, especially if you now start entering into agreements and negotiations, I would advise that you do a limited liability company, or you want to take loan or financing. So if you're maybe a fashion business, the extent of your transaction is someone commissions you to make a clothes, to make clothes for them, you collect their fabric, you give them back. That's not so much exposure. But you can imagine maybe you want to, so still as a fashion person now, using that as an example, you get a contract with maybe a GT bank. I know that like the GT staff, they wear uniform to make all their uniforms. You really do not want to do that as a business name. It is better for you to go and enter into a limited liability company, because to register a limited liability company, in case anything happens, GTB will come after your personal assets, down to your clothes and your generator, whatever in your house, if they decide that they need to recover funds, maybe something went wrong. But if it is a limited liability company, it is only the assets that belong to the company that anybody can come after. But in a business name, that's not the case. A business name, your COP, your computer, everything, your personal assets that they're interested in can be used to settle any liability. So yes, you can start with just a business name, business registration, but as you begin to enter into more sophisticated transactions and as you begin to grow bigger, I would advise that you then do a limited liability company. Okay, so we will move to scaling businesses now. We're done with running your business. So scaling your business, most times you scale your business, by the time you're scaling, you want to get funding. And the particular focus for scaling your business here is fundraising. You usually need money to maybe you've done 2 products or 3 products and you're now like, okay, we want to enter into a new product line. We have proved our MVP. We have done, we have confirmed product market fit. We have early traction. Now we want to expand into new states, or we want to expand into new countries, or we're making just 2 now. We now want to enhance the products. You need money to do this. You begin to fundraise. You begin to look for people that will support growing your business. There are different ways you can raise money. There are different types of fundraising. The most popular ones are equity and debt. Equity means, I will go to the others later. Equity means that the investor becomes an owner of your company. They are giving you money in exchange for shares. So basically meaning the share in the loss and the share in the profits of your company. That is what equity means. It is not a loan, it is ownership. Now, debt is a loan. I'm investing in your company, but I am borrowing you money for this purpose. I expect you to return the money, say maybe in 3 years' time or 4 years' time. I'm going to be attaching some interest. It's like any loan you will collect from the bank, only that maybe you're taking it from an investor now or something. That is debt investment. So in broad terms, every other thing is a variation of equity or debt, and I'll talk about the others. There's one that we call convertible notes or convertible debts. Usually what the convertible notes means is that, okay, at this point in time, it is a debt, but there's the option of converting this debt to shares in the future. I will go deeper into this, but I just want to give you a general idea of what it is for now. So I'm giving you debt, and I'm based on certain things. I might decide we might change it to equity in the future. Now, SAFE. The reason why I write about the SAFE and the KISS is a lot of Nigerian businesses and startups, especially the fintechs, they get into the accelerators outside of the country. These are not originally investment documents you will find in Nigeria, but they were introduced in other jurisdictions. Like the SAFE was introduced by the Y Combinator. If I enter in Y Combinator, what you find is a SAFE. And we've come to find that some Nigerian investors are also comfortable with the SAFE, and they will sign a SAFE that is customized to Nigerian laws to invest in you. What does a SAFE mean? It's an acronym for for future equity. Security agreements, I hope I'm right, for future equity. Please, can someone remind me, Shola and I think two of my colleagues on it. But it's for future equity. And basically what it means is an agreement for future equity is that I'm giving you money today. It is not a loan, but I'm not collecting my shares yet. I will collect my shares in the future. So it's future equity. I'll give you money today. Because we don't want to have the conversation about valuation, which I will talk about in a bit, you will give me my equity in the future when we talk about, when we start valuing your company. So that's basically what a SAFE is. And then a KISS, that's the one that's introduced by 500 startups. Thank you, Shola. My colleague has answered me. SAFE means simple agreement for future equity. I was close. It was the S I missed. I knew that didn't sound right. Simple agreement for future equity. That's what a SAFE is. Now, a KISS is also introduced by the 500 Startups Accelerator. That is what they use for people who come in. And most times you find that investors that invest along with time also go with KISS. A KISS means keep it simple security, right? It's a simple security for agreements as well, for investments as well. But I will talk about the terms. The one that usually comes up when it comes to any of these agreements is valuation. That's like the big, a term that usually jumps up is valuation. It's the big elephant in the room. Now, what is valuation? Valuation in literal terms means the value of your business, the value of your company. What is your company worth? Is your company worth 1 million naira, 10 million naira, 100 million naira, or can we not even value it in naira? We move to dollars because it's so valuable, or maybe because you're raising from outside investors. So valuation is basically the value of your company. Well, how do we arrive at this value? Because when you want to start raising investments, you now start getting all the questions. What is your valuation? And why do they even want to know what your valuation is? Especially when it comes to equity. That's when you usually talk about valuation. Why they want to know your valuation is it will determine how many shares or how much shares they end up having in your company. It will determine if we agree that your valuation, for instance, is, if we say that your valuation is 1 million naira, and I want to have 10% of your company at the end of my investment, that means that I need to give you 100,000 naira. Does it make sense? So I'm saying that I want 10% of your company. So if I say that your valuation is 900,000 naira, there's something called a pre-money valuation and a post-money valuation. A pre-money valuation is what is your company valued before my investments comes into your company. And then the post-money valuation is, by the time I include my money, the money I'm bringing as the investment, what is your valuation? So for a company that is valued at 900,000 naira, and I say I want 10% of that company, that means that I need to bring 100,000 naira so that I can own 10% of that company, and it becomes a 1 million naira company. That's why that conversation is important, because it determines the ownership of that company. Now, for bigger companies, valuation is based on their formulas. There are different formulas. Some will say the most popular being a factor of your last 3 years account. So we will take your audited account for the last 3 years. We will confirm that it is correct, and then I will multiply your revenue at the end of the year times 3, and that is the valuation of your company. For companies that have been in existence, there is a math applied to it, especially if it is not a technology startup, because there's less intellectual property attached. Intellectual property is hard to value. It's not tangible, right? How do I value the tech of Facebook? It's not like there's an accounting that if it's a machine, I know how much a machine costs. I know that the machine will depreciate over a certain number of years. But how do we value software? So those are the conversations that makes it a bit different when it now comes to tech investments, because one, especially if you just started, there are no accounts, there's no revenue for me to multiply by 3 or to multiply by 5. So I can't use that for your valuation. So it now becomes a discussion and a negotiation, but you still want to have some logic attached to how you arrive at that valuation, at that figure, that, because usually the founder will have a valuation and then the investor will say, it is very popular that founders generally have an overestimated impression of their value, and they will tell you, oh, my company is worth this. But you know what? Whatever number you're putting, make sure you have some logic attached to how you are doing it. So you probably want to have a financial model. You want to do your financial projection and say that, okay, because I know that I'm projecting that I will make this much revenue in the next 5 years, and this is how it's going to grow, this is what we need to do that. That is why I'm saying that this is my valuation. And also because we have this technology that is so great that nobody has done before, is utilizing. This is the amount I'm attaching to that. Or because the founders of this company were part of the team at Facebook or Google that this, they are so brilliant. For that reason, the founders are very valuable. This is what we should attach as the valuation. You'll find that second-time founders usually command a larger valuation than if it's your first time. So there are different things, but there should be a logic. It might not be it might not be math, it might not be firm math as you will have with established companies, but you should be able to justify your valuation. And most times, by the time you tell your investor, oh, this is why we valued ourselves at this, the investor will say, okay, this is why I don't think you are worth this. They would also have to give you reasons. And at the end of the day, you agree on what your valuation is. As commonly said, valuation is in the eyes of the beholder. As a founder, you will probably think your valuation is 10 times what the investor thinks. But together, you can reach a place where you're both agree, okay, this is what we think your valuation is. And it is based on that you now determine this is how much percentage that you can have in my company, because this is the amount of money you are bringing in as an equity investor. When it comes to debt, you usually won't have a valuation, and every other thing, whether it's debt, convertible notes, say for kids, you usually won't have a valuation conversation, because one of the reasons why you're even using that option is because we don't even want to have that valuation. And the debt is a loan. As long as you're paying my interest, it really doesn't matter what the value of your company is. Now, there's something called, and you will usually find that in a convertible note or a safe. It is, there's something called a valuation cap. Now, what a valuation cap means is when in the future, so if I say I'm giving you some money now for future equity, or I'm giving you as debt and we will convert it to equity in the future, to shares. At that point in time where you are converting me, no matter what valuation your other investors at that point, your other equity investors are bringing, my own valuation must not pass this. So let's say at the point where you're getting new equity investors that are doing the valuation, they say that the valuation of the company is 10 million naira. You who entered, if your Convertible Notes or safe investors had put a valuation cap of, say, 8 million naira, saying that whatever valuation you get, my own conversion is going to be at 8 million naira when I'm converting. Even though the other investors, when they're converting, even though they are going to be getting, let's say each share is 1,000 naira, that means it's 1,000 shares for 10 million. My math is wonky, I hope that is right. But for me, whose valuation is 8 million naira, mine will be 800 and not 1,000, the worth of my share. So I would get more shares than the person who's than the person who's investing at a valuation of 10 million. So these are the reasons why, like, valuation is the crux of, like, a lot of people when they're investing, what's my valuation, blah, blah, blah. That's like the focal point of everything when they're valuing. But one thing people forget as well is there are two very important things. And this is the same thing I mentioned when we were talking about companies. There's ownership and there's control. At the end of the day, valuation only addresses ownership. It doesn't address the control of your company. So when you have an investor, you also want to protect yourself in terms of control as well. So how many board seats am I giving up? Most times they will say they want to have the board seats. Ordinarily, you shouldn't give up more than one board seat. And then what control? What are the things that they want to say that they can veto, that they have decision on? These are the places where people usually shoot themselves in the feet. You would say that you will find investors, some investors will say that you cannot admit new investors unless they say yes. That puts you in a difficult position. What if the investor you have admitted already that you took money from has personal beef, not even, not a concrete reason, just personal beef with the incoming investor, and because of that, they don't then let you bring in the new investor. So you want to make sure that you pay as much attention to your valuation as control, even more so control. I find control to be very important because that determines the future. And investment is like a marriage, it's coming together. If you have the wrong investors, it can make or mar your business. If your investor is wrong, it can ruin your business. It will ruin your scaling. We're talking about scaling. It will ruin your expansion plans. So before even collecting anybody's money, what is more important is, if this person didn't have money, if this person wasn't bringing money into my company, will I want them to be a part of this business that I'm building? That should be your first question. If the answer is no, then you don't want that person's money. Do our values align? Do they, especially, if you also have a social impact pact to your business, are they all about money alone and not about impact? So you want to ask yourself all these questions before you take money, you fundraise from anybody. And those are the things you want to also see reflected. It's after you've established this, you then make sure that these are also even reflected in the documentation that you sign. Now, I'll talk about due diligence next. And I have mentioned that a couple of times when, as I spoke through this session. Now, a due diligence basically means that looking deeper, digging deeper, raising questions, answering questions. Before anybody will give you money, they will do something called due diligence. And to some extent, before accepting money, you should also do a due diligence. The extent of your due diligence as a founder is, has this investor invested in anybody before? The people they've invested in, the founders that they've invested in, do they like the investor? Is the investor, do they provide support? Or do they kick the owners out after a while? So that's the extent of your own due diligence, just making sure that the investors are investors that you want. But when it comes to the investor doing a due diligence on you, that is so much more deeper because they are parting with money, right? So they want to be sure that they are giving their money into a worthy cause. And we regularly, I can't say we've conducted, we regularly conduct due diligence. This is as Longe practice now on startups for investors and even our own clients that are startups, so that they are investment ready. We do an internal due diligence for them so that by the time they are raising money, they can easily answer all these questions. So typically the way a due diligence goes is you create something called a data room. And then you put all your documents in that data room. And then you will also answer a questionnaire. The lawyer of the investor will send you a questionnaire or a list of things that they want you to put in the data room. A data room could be a Google Drive folder, a Dropbox folder, or anything. So what do they want to see? What are the common due diligence questions? What is your capitalization? Who are your shareholders? What are the major agreements you have? They want to know what major agreements are you exposed to? What is the IP ownership? Do you have registered IP? Have all the founders and employees assigned their IP to the company? All these things that I've been talking about, they are going to confirm it during your due diligence before they part with their money. So there's legal due, but what I didn't mention is there are different types of due diligence. They do several. So an investor will do legal due diligence, they will do financial due diligence, they will do technical due diligence if you're a tech company, and sometimes some do something called commercial due diligence. The financial due diligence is checking your numbers, your accounting records, your bookkeeping. They want to confirm there's no fraud in the company. They want to confirm there's no mismanagement. They want to confirm whether you've been auditing your accounts. That's where financial due diligence comes in. Your your technical due diligence, do you have the technology you claim you have? They will get an experienced developer that has coded in the language that you claim to have developed the app or the website with, and they will make sure that, just to make sure that the tech you claim you have is what you have, or the tech you claim you can build, you can actually build it. Then commercial is, do they really have any customers? They will want to speak to some of your customers. They will want to speak to some of your vendors or some of your partners. They say they have you've claimed that you have a partner with some bank. Do you really have that? So that's where commercial is. There really a market for what you're producing? That's where the commercial, but the legal due diligence, which is where I'm really focusing on since this is on legal, is them now checking, and it is so important. If nothing, the very minimum any investor will do on you is a financial and a legal diligence. They might not do the remaining, but they will always do financial and legal due diligence. Now, for legal due diligence, they're checking all your agreements, they're checking your filings, they're checking your tax exposures. If I give you money, I don't want you to use my money, the money I'm investing in your company, to go and pay fines. So have you been doing your filings and your reporting? If there's a potential liability to an FIRS, I want you to settle that before my money comes in. The money should be for the development of the business and not for payment of fines and not for payment of regulatory breaches. So your due diligence will be confirming those things, that there are no regulatory breaches, that there's no litigation, there's no conflict, that all the IP has been assigned, that the legal due diligence will also confirm if you've received money before, what were the investment terms, what are, but generally your legal paperwork, almost everything that I've asked you, they would in one form or the other want, that I've almost everything that I've spoken about in the previous slides, they will want to confirm that through their legal due diligence, that all these things are in place. Do you have a rent? Do you have a lease? So it's important to, if you've been doing the right thing from the beginning, this will not be a challenge. The only thing you need to do is to arrange them into a data room, is to put them into the box, and it won't be a challenge to you. Now, how is an investment done? The first thing that will typically happen when the first thing you're typically issued when you're raising funds is something called a term sheet. A term sheet is similar to what I explained as an MOU. In fact, they mean the same thing. If you check for the meaning of, they'll tell you a term sheet is otherwise called an MOU, and an MOU is otherwise called a term sheet. It is a non-binding document, but it documents it's just a document that talks about our understanding and the terms we want to invest in. So you will see a caveat in most term sheets. You will see a caveat that says that this is not a binding document, that the document is subject to negotiations and is subject to the investor conducting a legal and financial due diligence, blah, blah, blah. It says until your due diligence is confirmed that they will now sign substantive documents. But it's in the term sheets that you already know, okay, what is the investor value my company has? That's why they'll talk about this is the valuation. That's why they'll talk about these are the number of board seats. These are the rights I want. So I want to have veto rights. They will talk about, do I want to get out after 5 years? Do I want to collect my money back? What are the exit mechanisms? How do you raise funds? So the term sheet is the start of your negotiation. The term sheet is usually signed, and there's usually a period, a buffer period. So you typically say that this term sheet is binding for the next, say, 60 days, or this term sheet is binding for the next 30 days. And during that period, you are not allowed to talk to anyone else. And it's only after that, because they want to, they want time to do their due diligence and to know you better. So during that period, they might say you should not talk to anybody else, and it's all stuff that you negotiate. Then subsequently, after the term sheet, you then sign the substantive agreements. Now, the substantive agreements depends on the kind of investment. If it's an equity investment, when it comes to shares, then you're looking at shareholders agreement, which talks about, this is where you now add more flesh to all the things that were in the term sheet. How many boards, how are board meetings held? How are shareholders meetings held? Who must be in attendance? When is it that a meeting is valid or not? It talks about corporate governance mostly, and how meetings and processes are done. Then you have something called a share subscription or share purchase agreement. This has to do with the commercial terms. Sometimes it's joined together, the shareholders and the share subscription or purchase agreement comes as a single document. Sometimes it's separated. But the subscription part will typically deal with the commercial terms of the investment. So how much am I giving you for what equity? What is my money buying? How much it is, and where am I sending this money? And what is true as at the time I'm sending the money? You use the word subscription when the money is going to the company. I am buying shares from the company. But when it's maybe I am buying from existing shareholders, maybe a founder wants to take money off the table. So it's not the company the money is going into, but I am buying from the founder. That's when you talk about a purchase, because it's then a purchase between the two shareholders. Or a note purchase agreement is what you use for a convertible note. It's basically an agreement that says that the investor is buying a note issued by the company. So a note is a sign of indebtedness. It's a sign of, it's an IOU basically. So the note purchase agreement has attached to it something we call the promissory note, which is like an IOU, and it documents the terms of the convertible notes. When will conversion happen? What is the valuation cap? How long is the loan for? Is prepayment possible? Is conversion compulsory, and all of that? A safe agreement is the agreement that discusses the terms of the safe, and a KISS agreement discusses the terms of the KISS, And these are simple agreements, actually, both the safe and KISS. They are less complex than the other agreements because they were done for that purpose. They were created to simplify the entire process of investment, and they are standardized. They've been issued by the company, so you really don't have much flexibility in amending them, or they fail to. Once you do too much amendments, then it's no longer a safe agreement or a KISS agreement. So I've actually come to the end of my presentation, and I am open to any more questions that you may have. I had said I was going to mention vesting again, and I forgot. Usually an equity investor will make sure that you have vesting in place. It's part of the things that will go inside the shareholders agreement, actually, just so that they are sure that when they invest, you do not run away and you stay there to build the company. Okay, are there any questions, any clarification you need? Has the session been useful?
Extremely useful.
Thank you. It looks like I don't have questions, so I'm just going to go to the place with the contact details, and then I can stop sharing my screen. These are contact details for DIY Law.
Dora, you can just leave don't stop sharing your screen. You can just leave it there so people can have a look while they're asking them.
Okay. So so these are the contact details, and I'm happy to take any questions, but I don't see any questions at the moment. So I want to believe that I must have been a very, very good, I really explained very well. Oh, okay, someone is breaking my, someone has asked a question. I was already feeling myself. All right, it says, how do small business owners manage these documentation processes with the high cost of getting a lawyer? When it comes to raising funds, please don't, you can do everything. Every other thing that I said you should get a lawyer for. It's okay for you not to get a lawyer. But the minute you're raising funds, please never ever take this step. without a lawyer. It is so important. You can tie yourself into a very, very bad deal. As I said, an investment is almost like a marriage. You can build everything you have worked for. If you do not get the right if you do not get the right investor, or you do not sign the right terms, then quite a number of lawyers now that work with small businesses and startup. It's okay. They're not as expensive as the big law firms. It's okay to talk to them. And we also, through the DIY law does not do legal advisory, but through the Longe practice, we also advise businesses as they raise funds. You can, when you get a lawyer, have an arrangement. How much will I, for us at the Longe practice, there's something we call the fundraising advisory service, which is just us advising you through a fundraising process, the legal aspects of the fundraising process. The way we charge is you pay a certain amount, a percentage, before you raise funds. Then if you successfully raise funds, that's the only time we will get our balance. I think you pay 20% or 25% upfront. The remaining 75% is only if you successfully raise funds. If you don't successfully raise funds, we don't get that balance. So we kind of have skin. And I'm sure we're not the only one that has this arrangement. Speak to a couple of lawyers. They're lawyers that style themselves as small business lawyers or startup lawyers will have some payment system that can work for you. But do not say that you want to get this for free. It is service, it is time, and they should be paid for what they do. And it's an investment worth making to protect yourself. How do we get our TIN, or do we get business TIN? It's through the State Inland Revenue Service. For Lagos State, that will be the LIRS. You can go there to register. However, you can also get it on DIY Law. DIY Law has a service. You can apply for a TIN through that. But the typical process is to go to your State Inland Revenue Service. There's a form you will fill. They want to see your incorporation documents, and then they generate your TIN for you. And it's that TIN you use for your subsequent filings. Are there online platforms where I can register my business? Yes, that's what DIY Law does. I failed to put the websites there, even though I put everything on the contact. It's diywlaw.ng, www.diywlaw.ng. Yes, you can register your business through them, and you can send a mail to hello@diywlaw.ng if you have questions on business registration. Can I successfully register a company through your organization without my physical process at the CSA? Yes, you can, and that's what we do. You can also, in the spirit of transparency, you can also register your business by yourself through CAC, but at some point you have to go there physically. You can't collect your certificate until you go and submit your forms physically. So even though the CAC now has an online portal that allows you to upload documents, the point of collecting your certificate, you have to go there physically to pick that up. But with DIY Law, we pick up from your place of residence and we deliver them. We pick up your certificate for you and we get it to you there, no matter where you're in Nigeria. DIY Law registers for people all over Nigeria, and you don't have to be physically at the CAC. How do small business and startups in the rural areas have access to such vital information? I don't know. That's like a big question, but I totally agree with you. One of the things we do at DIY Law is we've partnered with certain banks, and sometimes when they go to those areas, this discussion we are having with a particular bank now, when they go to such areas, they want us to come with them to be able to also do such sensitization. But you see, what you find is most people in rural areas don't have internet, and what we do is we actually have physical forms that they will fill in handwriting. We've also done some in Lagos markets. We go to markets, it's something we call market circuit, and we do free legal advice. And then if you want to register your business in the market, we give you a physical form, and we just do it physically. So there's that. How do small business? Okay, I think I have answered everything. How much? Oh no, there's one. Sorry, I missed some. How much is registration fee for a limited liability company at DIY Law? So without taxes and courier, it's 55,000 naira if you're doing a 1 million naira share capital. I know that VAT has been increased. So in addition to the 55,000, there'll be 7.5%. And then depending on where you are, there's a career service. If you attend Covenant University, we have something with Covenant University that gives you a discounted fee. And I think maybe it's something we should also look at with Edustart and not just Covenant as well, but that's the discussion we'll have. Can we get the recorded presentation? Is that possible?
Absolutely. Yes.
Yeah. Okay. Says yes. Can I get support assistance in pushing my business? My contact details are here. My email, I'm best contacted by email. You can send me an email. Even if I don't reply on time, I will eventually reply you. But yes, please send me an email. The phone number is actually for DIY law. So, but if you send me an email, I will get back to you. And to the extent I can help, I'm happy to help and support. Have I answered every question? I think I have 10 online platforms, company through your organization, small business and startup in rural areas, high cost of getting a lawyer, registration fee, recorded presentation, support and assistant. Is it possible to make an arrangement with you or your company to bring you for seminars in the rural areas? We can talk about it. Send an email, and depending on the logistics, we do schools, we do seminars in schools, we work with partner organizations, but yes, that is possible. But please send an email and then we can discuss. Phone number not complete. Sorry, 070-341-41855. I'm repeating the phone number in case it's not. Oh, there's a 41 missing. So it's 070-341-41855. Let me see if I can put it in the chat for everyone. Sorry, there's a mistake on the phone number, and it's 070-341-41855. Okay. Yeah, I hope you got that. Are there any more questions? Phone number. How do we handle dilution? There's a new question. How do we handle dilution of shares which are currently vesting when a new investor comes into a company? So there are two ways that happens. There's something called resetting of vesting, and sometimes some investor will insist on your vesting resetting because they're just coming into the play and they don't know what you've done. Well, sometimes some investors, because you already have vesting in place, if say maybe it's just 1 year that has vested, they might decide not to reset your vesting. It's a conversation you have at that point in time. And sometimes they say, okay, instead of you starting from 0, you start from 25%. But typically there will be that conversation around whether we are resetting the vesting or we continue with the vesting that's already in place, or we are starting afresh. Yeah. I think I have answered most of the question. I'm taking answer live so that I can know that I have answered. Yes. Okay, I think I've come to the end of all the questions. I've answered the dilution one. Thank you all. Thank you very, very much for your time, for listening to me. And thank you for your active participation. And yeah, feel free to get in touch. That's it.
Thank you so much, Odun. This is highly impressive. Can you just click the raise hand button, everyone, just to appreciate Odun for this massive value-adding session. You can see the raise hand button somewhere there in front of you. Oh, see the number as well. Awesome. Thank you so much. I really appreciate it.
Thank you very, very much. Thank you for having me.
Thank you so much. I really appreciate it. I'll still engage you personally on some questions that I have. I just wanted our audience to also have a very good part of you and also learn a number of things from you. Thank you so much. This is also on YouTube right now. So for anyone who misses it, they can always go back there to watch and learn a number of things from what Odun has shared. Odun, thank you especially for what you've done. And also want this opportunity to thank you for what you do at Edustart and the value you add. I've gotten some few insights, which means I'm going to disturb you a lot more on how we our corporate governance at Edustart Global Foundation. Thank you so much. I really appreciate it.
You're welcome. Thank you very much. All right. Thank you, everybody. And thank you for your active participation. Enjoy the rest of your day.
And also to our participants, please take note, for the things that Odun has shared, please get in touch with DIY Law, all those agreements from NDAs to founders agreements and the rest of them. We can all get in touch with all those details from there. Thank you so much. Odun, thank you once again. I really appreciate it. So bye-bye, everyone.
Bye.
Yes.